Hey, good morning, everyone. I'm Chris Parker. This is Kristen Ishihara. We're with the Ishihara and Parker Law Firm here in Longview, Texas. And today we have a topic that we see arise more often than we want.
Yeah.
We call it basically a lost will or a missing will, a situation where a family member or an heir has came in and they have brought us a copy of the will and it needs to be probated, which means we got to go to court and handle it. And that starts us down a rabbit trail of things we have to do. Kristen, what can we do with a copy of a will?
Yeah, sure. First, I want to be real clear about what we mean when we say lost will, because it's not immediately obvious. Everybody that, brings in a will is like, what do you mean? I have the will here. So when the court refers to a will, they mean the original wet signature will. They mean the one that was signed. There's only one out there, not a duplicate, not a copy. That is not the will. When you probate a will, within 3 days of filing, you have to turn into the court the original wet signature will. That is how you probate a will. Otherwise, you are doing something different, which is the process we're going to talk about. But what we wanted to highlight today was just how important it is to have possession of the original will, that you have done for yourself, and that your executor knows how to find it, has access to it. And if you find yourself without an original will, you might want to do something about that. Go back to the attorney, sign a new one, make sure that you have the original will, because it does make a difference. It is required in the probate process. And if your loved ones and executor do not have the original will, then you have what is called a lost will. A copy of a will equals a lost will. That is a lost will. That's what we're talking about today. So it is very important in the process that you make sure that the original exists, that someone has access to it, because that's what they will need to probate it. That is the easiest way to do it. If you want things to go smoothly, that is a very important aspect of that. So if, however, let's pretend that the decedent has passed away and all that can be found is a copy of a will, there is a process to probate a copy of a will. So you're still not probating the will, you are probating a copy of the will with some extra provisions. We're going to just talk straight out of the estates code today and tell you what those extra provisions are. Do you want to talk about the requirements in the pleading?
Sure. So when you are filing this application for probate of the lost will, you are going to have to make some separate statements, basically. You are going to have to establish why that original will cannot be located. The law will presume that the original was destroyed because the creator had the intent to revoke, and therefore you have to rebut it. I've seen many situations where families come in and it's a very simple will, leaves it to the two kids in equal shares, but they can't find the original. And suddenly we start asking, well, what was the process? Well, mom and dad had it. It was a medical event. There was people in the house. Eventually the apartment was lost. Home health was involved. Things were shifted, went to storage. Maybe there was a fire. I mean, these things, everyone has the best intentions and they just... sometimes they're gone. House fire, moving, just don't know. Parents were secretive. I mean, these things happen regularly. So we will have to present to the court why we believe the original is not here today. The court may require testimony on it. They're going to need evidence of why that is to rebut the presumption that what's in the will was destroyed or canceled by the testator.
Right. And if you think about that, what the court is trying to safeguard here is, the decedent is not there any longer to tell you if it's their last will and testament. The court wants to make sure that what they're approving is the will is, in fact, the testator's wishes. So when a testator, if we sign a new will with a client, we tell them to physically destroy an old will, but that doesn't mean that other copies aren't out there. Right? Mm-hmm. So there certainly is the capability that the testator intended to get rid of that will, and that is just a copy. So the court is doing a good job, doing what they need to do to make sure that this is what the testator wants. But for an individual who's trying to probate that will, knowing that it's what mom and dad wanted, it can be really difficult.
Yep. Okay. So we're working on our pleadings, and since we're dealing with a copy of the will, we know that everyone listed in the will, this copy that we're using, is going to be noticed and served. I believe they're going to have to be served about the hearing. They're going to have to know about the court case.
So only for the heirs.
Only for theirs. Okay. So what that means is if you have, let's just say you got two kids, they both get along, and you're leaving it to your two kids in equal shares, well, guess what? Your two children will be able to sort it out because they get along and they're your natural heirs. Where the problems arise is if you have a will that does not follow the natural disposition under Texas law. If you start making decisions saying, hey, I'm leaving everything to daughter and nothing to son, a lost will scenario both children are going to get notice and have a chance to go to court to argue about why that will is missing.
Right. The distinction here is really beneficiaries are the people named in the will. Heirs are the people that under Texas law would be entitled to inherit. So there's a conflict here, right? So if you have two kids, those are both your heirs. So if you had physically destroyed your will, they would both inherit equally. Whereas if your daughter is the only beneficiary listed in the will, she would be the only one to inherit if the court were to admit the copy of the will to probate. So the court is trying to, through the pleadings, invite any party who might have a contest. So the daughter can't just probate the will and say, well, this was dad's intention, he only left it to me. She's got to notify her brother, who has a chance to hire a lawyer, come appear in court and fight her and say, well, I know dad intended to get rid of this will. He told me he wanted me to be included. So we've drawn basically a contest to the proceeding by not having the original will to get to court. Because if you had had the original will, daughter would probate the will, not notify the brother in any way because he would have no right to know as not being a beneficiary of any kind.
Yep.
Yeah. Yep. So really makes it hard maybe on somebody that you're intending to try and leave everything to.
Yeah.
They got to go kick the bucket.
Yeah. The very thing you were trying to do to make it easy for someone to inherit has now become more complicated, unfortunately.
Right. And the specific provision here is 258.002. When you file that application, you have to get citation and personally serve an individual who is an heir under Texas law. So sister, in filing that application, would have to get citation from the court, get a process server to serve with process the brother legal papers so that he knows you are probating a copy of the will and asking the court to approve why you don't have the original and that those were still the testator's wishes. So, we talk a lot about trying to avoid having a conflict, having a contest, making it as easy as possible. This is one of the worst ways to just serve on a platter to somebody who's mad that they're getting cut out of a will.
Yep.
Here's your opportunity to come contest it. Here's the error that we have. We don't have the original will.
Yep. Yep. And of course, this is very common. So just be aware of it. If you have written the will, let's make sure that original is kept safe. If you're the recipient, a beneficiary of the will, you want to make sure that that original will is kept safe and located. Part of securing upon death, you want to make sure that that's taken into possession.
Yeah, all that to say, we probate a lot of copies of wills because this is a very common problem, very common situation. Hopefully everybody is, getting along and it's not as bad as we've made it out to be, but I have had those cases. So it is important. If you are listening, I want you to know that you have the original wet signature will for yourself, for any of your loved ones that you may end up being a beneficiary or the executor, and that you know where to find those things. Absolutely. That will make the process much easier, much simpler, and much less potential for conflict. Yeah. Good. Anything else you want to add?
That's it.
No? All right. See you next time, guys. Bye. Thanks.